Muthomi Thiankolu, who is from the Muthomi and Karanja Advocates. He's dealt with a number of election petitions in the country. So as we take a look at the timelines that we have, what we expect to come out, we know that we can't really talk about much that we've seen in court. There are a lot of restrictions, but in the next few days, from what we are seeing today, what do we expect to see in the next few hours until when the respondents begin to give their submissions?
Many things. If you remember from yesterday's status conference, the judges allocated the various parties certain timelines within which to present their cases. Yeah. For the most part, today we've been hearing the petitioner, that is the NASA coalition, present their arguments and their evidence and their case in summary. They were given 5 hours in total, if I recall. Then you recall there were other people besides the petitioner and the respondents who were allowed to join the case either as friends of the court, otherwise known as amicus curiae, and other persons were also allowed to join this case as interested parties. Now, if you recall yesterday's timetable, basically this last category of amicus curiae and interested parties were given roughly 20 minutes each. The IBC and its chairman were allocated 3 hours, and Uhuru Kenyatta, as the person whose election is being challenged, was given 3 hours. So today we've been hearing the complainant's case, and so far I think it's proceeding well. They are almost exhausting their timeline. And the next stage will be to hear the interested parties who are supporting the case. Some of the interested parties are opposed to the case, others are supporting it. The sequence of events is that all the persons supporting the case will make their presentation shortly after NASA makes their presentation. And then everyone who is opposing the case will make their presentation. The amicus curiae are not allowed to oppose or support the case because their participation is confined to limiting, or rather to clarifying issues of law.
Once, because the issue of accessing the IBC server is still a big one in this particular case, so once they have gone through everything, accessed the server, how do we expect that conversation to be brought back to the courts after they've made their submissions for 5 hours?
That process will be akin to what lawyers call scrutiny, which means the teams from both sides, that is NASA and Jubilee, will appear at the relevant places you must have had in the morning, and then they will access this material. They will make whatever observations they may consider relevant for their respective sides. And more importantly, the court itself, if you add the directions, this process usually takes place under the supervision of the court. And the person representing the court in that exercise will be the registrar of the Supreme Court. And I would imagine should be backed by a whole coterie of court staff, usually deputy registrars, IT experts. And usually what happens is the registrar will prepare a report. As they access all that material and make whatever observations they consider relevant to whatever side, the court itself will be making its own independent observations, and it is those observations which will be brought to the court in a report by the deputy registrar.
The ruling that was made yesterday on who would be joining in as an interested party or an amicus, just take us through the dynamics. At what point can the court decide that you can be enjoined as an amicus curiae or an interested party, or at what point can they throw up? Because we saw a number of people whose applications were thrown out.
These two categories of people, the fundamental distinction between them is if you're an interested party, it simply means you have a stake in the outcome of the case, and that your interest is that the case stands this way or the other way. So you will note the people who are joined as interested parties were largely people who are candidates in the election or people who had some interest. Actually, the phrase itself, interested party, connotes that you have an interest in the outcome of the case. and you would only be allowed, or you would only have an interest if you can demonstrate that the determination of the case, one way or the other, will affect you. Now, for you to be an amicus curiae, you need to be shown to be an expert in an area of the law or in an area of knowledge that is relevant for determination of the dispute. Now, importantly, you must be able to persuade the court that you are not only an expert, but your expertise is such that it will be relevant in assisting the court to determine the issues. As an amicus curiae or as a friend of the court, you're not allowed to descend into the arena of the dispute. And you're not also allowed to address issues that are best left to the parties. If you recall the ruling, there was always a question being asked, what is it you will address as on, that the parties are either ill-equipped to address as on that issue, or you think they will not properly address it. And the amicus brief, if you follow the proceedings, is supposed actually to be confined to issues of law that the real parties, let me call them the real parties, because an amicus is not a party to the case. He is gnostic. Your only interest is to ensure that the court reaches a decision that is intellectually sound, that is legally defensible, and that is well balanced in all due considerations.
Looking at the presidential petition in 2013 and how these proceedings have been so far, what are some of the comparisons you can draw?
There are many comparisons and perhaps contrasts. As you may have noted, it's largely the same players. Yes. Some may have crossed the floor and joined either NASA or Jubilee, while the last time they were on this side. The composition of the court is largely the same, save for 3 members who have come following the retirement of the former Chief Justice and 2 of the judges. You realize the same questions of technology and its role in elections has come again, except that, as you may have seen from some of the presentations, maybe the legal landscape has changed in a significant way, so that I would imagine some of the issues, in fact, most of the issues, may require a fresh reflection as opposed to the approach in 2013, due largely to the legal amendments that we made in 2016 and 2017. So in short, there are many parallels between the 2013 and the 2017 presidential election petition, but it's important to point out also that there are many fundamental differences arising mainly. If you recall, the 2013 election was largely manual because of circumstances the country was told were christened failure of technology. Yeah. Now, this time we didn't have a catastrophic failure of technology, and the allegations seem to revolve around the integrity of the system that was put in place and its security and whatnot. So we would say there are many similarities, but also many fundamental differences. Yes.
So in the coming days, what really do we expect to see?
What we expect from this stage is the parties will make their respective submissions. They will point to their respective evidence. The registrar will bring the report on this scrutiny about the ICT system, and lawyers will be allowed, or the parties will be allowed to make whatever submissions they may wish to make about that exercise. After that, the hearing will close. And once the hearing closes, the judges will retreat to consider all the rival allegations and counter-allegations, all the submissions and counter-submissions, the various legal points raised by the various sides, and the judges will go into conferencing to make a decision. That decision must be rendered within 14 days of the date the petition was filed. So the judges will go into conference, and this simply means the judges will retreat to their chambers. Yeah. They will discuss and ask one another, what are your impressions of this case, and what is the general direction do you think our decision should take? Is it to nullify this election, or is it to sustain it? In that conferencing itself, there may be either unanimity or there may be differences of opinion. If they are unanimous, we'll get a unanimous decision like we got in 2013. If they are not able to agree on some or all the issues, it is possible to have what lawyers call dissenting opinions. That is to say, a judge of the court is entitled to say, fine, this is the majority position on this case, but I disagree, and they're expected in their ruling to show alternative reasoning that forms the justification for them disagreeing with the majority. We could also have what the politicians have been calling, each judge should write their own independent judgments. The truth is the court is at liberty to follow any of all these approaches, and none of them is enjoys any legal superiority to the other. At the end of the day, our Constitution says that the decisions of the Supreme Court shall be by the majority of the judges voting. And it's important, maybe our viewers, to appreciate when the Constitution says this, it is also an appreciation that judges and lawyers, just like every other citizen, may not necessarily always agree on matters of public importance. And I think it is those disagreements that make our democracy beautiful.
All right, and if you're just joining us, remember we have been live from the Supreme Court, where NASA lawyers have been giving submissions for the past 4 hours. Currently, the court has adjourned for about an hour till 3:30, when the hearings are expected to continue, and NASA will have another hour to wrap up their submissions before now the interested parties who are for their arguments will also be given a chance. The interested parties in this case will get about 30 minutes to give out their submissions. But let's quickly run through some of the things that have come out from the NASA lawyers while they were giving submissions. We've seen a number of their lawyers taking the stage. One of them, Otiende Amolo, Okongo Omogeni, as well as Paul Mwangi. This team is led by Senior Counsel James Orengo, and we saw lawyer Paul Mwangi say that in this particular election, forms 34Bs and As were supposed, Form 34As were supposed to be supported. Form 34Bs were supposed to be supported by Form 34As, so they've punched holes in the manner in which IEBC conducted itself as far as Form 34As and Bs were concerned. They've pointed out a number of inconsistencies in this particular Form 34Bs and As, going as far as sampling these forms from various polling stations in various counties in this country, one of them being Isiolo. They mentioned a polling station in Rabai, and just looking at the differences from what was there in the IEBC portal and what they got from the Forms 34As and Bs. So the lawyers were seeking to punch holes in the arguments that have been there from the IEBC. Remember, they have been on record saying that what was on their portal that Kenyans were looking at since 8th at night was not really what they depended on to make a decision on who won that particular election, but mere statistics. And we also saw Paul Mwangi say that different from what we saw in 2013, this year really there was no failure in technology, and there should not be word that really technology failed us this year like what we saw in 2013, but instead he said that this was done very purposefully. If there was anywhere where technology failed, the argument that Paul Mwangi, the lawyer for NASA, gives out is it was purposed and it looked like it was designed. We also saw Kongo Omogeni, who said that 7 days really were not enough for the petitioner to prepare for a presidential petition. Remember, there has been argument that why did NASA take this long to bring their case to court if really they wanted to petition it. After the results were announced, about 3 days after Kenyans took to the polls on the 8th of August, NASA immediately indicated that they will not be going to court, but after consultations they finally agreed to take the matter to court. And this brings us here where we are now. But something else very interesting came up while Okongo Omogeni was giving his submissions, accusing cabinet secretaries of campaigning for presidential candidate for Jubilee, President Uhuru Kenyatta, saying they violated the law adversely when they campaigned for President Uhuru Kenyatta, going as far as arguing that there's no way they would be campaigning for him if President Uhuru Kenyatta really did not allow for it to happen, and there's no way he was not aware for this. So pointing out some of the irregularities that they say went about in this particular election, and just putting trying to put up a very strong front or a strong case for the judges just to hear them out as far as this particular case is concerned. A number of cabinet secretaries have been adversely mentioned in the submissions by NASA through lawyer Okongo Omogeni, who even says that state resources were used to campaign for President Uhuru Kenyatta. So these are some of the things that have been put forth. The sampling of Form 34As and Bs, random sampling of this form, saying there's large inconsistencies and irregularities in the manner in which this was conducted. Remember, they've punched holes in the whole system, the integrity of the whole system that was used. And then there's this new angle of cabinet secretaries allegedly illegally campaigning for the President Uhuru Kenyatta. So this is some of the things that have come out of the 4 hours of submission by the lawyers for NASA, led by Senior Counsel James Orengo. We've seen Otiende Amolo, we've seen Okongo Omogeni and Paul Mwangi. So in the next 1 hour after the break from 3:30, we will be seeing them get back to wrap up their submissions. But before we close it, how do you assess this whole case? I know we can't talk much about what has been said in court, but your assessment of the whole procedure.
I think they have done largely as expected. If I understood the presentation, Senior Counsel Orengo's presentation was about the relevant constitutional and legal principles. Let us note there is a distinction between rules and principles. And if I understood him well, his case was that our constitution has certain articles, 81, 86, that lay out certain minimum thresholds that must be met. And of course, his narrative is that they were not met. Then the presentation by Otiende Amolo was largely about discrepancies. It was largely about discrepancies between either the official results and the results that were actually announced. It was also about errors and irregularities. And now this tie up with Orengo's submission is with regard to the constitutional principle that an election must be verifiable, must be correct, must be accurate. We went through that drill of Article 81 and 86. If I understood, and the real elephant in the room is in the submissions by lawyer Paul Mwangi, because he spent a lot of time talking about the threshold for nullifying an election, because the general legal thinking, not just in Kenya, but in most Commonwealth countries, is that it is not enough to say 1,000 mistakes took place in this election. There is a certain legal threshold you must show, and it's twofold. And in the alternative, you can show a breach of the constitutional principles that I talked about, or you can show that whatever took place has affected the outcome. For me, the real issue, once they get there, really will be what is the place of Section 83 of the Elections Act in the new constitutional dispensation.
All right, thank you very much. Muthomi Thiankolu is a lawyer, has dealt with a number of election petitions. Thank you very much for coming in. This is a conversation that we will definitely have once again tomorrow.